Good morning. Oh, there he is. This hearing is called to order. I'm Commissioner Tony O'Donnell, the presiding officer for this hearing. And with me today is President James Brown. Commissioner Randy Pinocci will be joining us. Oh, here he is. Speaking of that, Commissioner Fielder, are you with us? Commissioner Fielder? I see. What?
Yes, I'm here. I'm sorry, I had a sticky mute button.
Very good. Thank you. And Lucas Hamilton, Laura Wachowski, and Dan Polkov will be advising the commission. Commission staff are also present. Their hearing is being transcribed by a court reporter with Lasovsky Court Reporting. And for the record, the time is 9:02. The date is Tuesday, December 13, 2022. The commission and its staff appearing from Helena, Montana in the Bollinger Room of the Montana Public Service Commission. This is the scheduled public hearing in docket number 2022.07.073 involving the petition of Colstrip Energy Limited Partnership to set terms and conditions for a qualifying small power production facility pursuant to Montana Code annotated 69-3-603. I will now take appearances of counsel. Please introduce yourself and who you represent.
Good morning. Thor Nelson of the law firm of Holland and Hart, appearing today on behalf of the petitioner, Colstrip Energy Limited Partnership, or KELP.
Very good.
Morning, Chairman, Commissioners, please enter the appearance of Jason Brown, Montana Consumer Counsel. Thank you.
Good morning. My name is Clark Hensley, and I'm appearing on behalf of Northwestern Energy in this matter.
Thank you. I guess we should have had an extra microphone right there because Mr. Brown here tends to dominate hearings with his verbosity, I think. That's for those. Well, my meaning is he never speaks. Anyway, so recesses will occur at convenient times during the hearing. I will next ask for public comment. Is there any public comment in the room?
Mr. Chairman, if I can have a point of personal privilege.
Sure.
I would like to recognize the fact that we have Commissioner-elect Annie Bukacek joining us this morning. So please give her a welcome. She'll be joining the commission in January. Thank you, Mr. Chairman.
And excuse my social faux pas for not acknowledging Dr. Bukacek. So anyway, no public comment in the room. Is that correct? Is there any public comment online? None there. Okay. Are there any informal questions from the parties before we begin the evidentiary hearing? As unusual, thank you. Okay. Seeing now, we now move to the evidentiary hearing. Based upon the parties' pre-hearing memos, there are a few items we should address. First, we have a request to allow Luke Hansen, Jason McClafferty, Jim Williams, and Andy Durkin to testify remotely via Zoom if necessary. I understand that this motion is unopposed. Mr. Nelson, Mr. Brown, is that correct?
That's correct.
Very good. Thank you. So next, let's address the admission of data responses. The request is hereby granted. Thank you. Okay. Address the admission of data responses. The parties have filed pre-hearing memos identifying responses they propose to admit into evidence. I believe MCC's pre-hearing memo was the most expansive because it proposed to admit all responses except those specifically objected to. Northwestern filed a pre-hearing memo objecting to a long list of data responses. Mr. Hensley, I'll give you the first opportunity to speak to your objections. You may address them one at a time, in groups, or all at once. What is your preference?
Chairman O'Donnell, after consultation with KELP's counsel, Northwestern doesn't have any objection to the exhibits they plan to enter into evidence today, but with one caveat, to the extent those data responses contain legal conclusions and argument, Northwestern maintains its objection consistent with what its motion in limine. And if the commission desires to maintain consistency and rule on those in post-hearing briefing to the extent necessary, I think that's entirely appropriate.
Sure, please.
If I may, Mr. Chairman, thank you. Lucas Hamilton on behalf of the commission here. Just so I understand, Mr. Hensley, are you saying that you will withdraw your objections to the data responses, except for those objections that were based on legal conclusions?
That's correct.
Okay. So at this point, then, the only objections that are the subject of a pre-hearing, the only data responses that are the subject of a pre-hearing objection are those that were identified as legal conclusions in your pre-hearing memo.
That's correct.
Thank you for the clarification.
Mr. Nelson. You want to respond to Northwestern's statement?
Is the commission intending, we've done it a couple different ways over the years. Is the commission intending to entertain the admission of the data response exhibits in advance of the witness presentation, or is it the commission's preference that we do that through the course of the witness presentation?
Mr. President, that is correct. Typically, or at least in recent history, the commission has entertained a motion to broadly admit data responses before the witnesses take the stand. And as I understand MCC's pre-hearing motion, the motion would be to admit all data responses that are not the subject of a pre-hearing objection.
Thank you.
Mr. Brown, anything to add to that? Thank you. Okay. Thank you all. Due to the the volume of objections, but previous objections that I have to rule, and I intend to issue my ruling in writing so the parties can refer to the ruling throughout the hearing. And we will issue that ruling after the hearing. So I would now entertain a motion to admit all data requests that were not the subject of a sustained pre-hearing objection.
So moved.
Yeah, any other objections?
No objections.
Very good.
I'm here.
Hensley? The motion is granted then. Thank you. Are there any other formal pre-hearing matters such as requests for accommodating witnesses, stipulations, or evidentiary motions?
Mr. President, did you indicate on your list, and maybe I missed it because I wasn't paying close enough attention. We had requested that Mr. Bill Lovejoy also appear remotely by video, and I can't remember if that was part of your motion. And if not, I would make a motion that Mr. Lovejoy on behalf of KELP be allowed to appear by video as well.
Any objection to that?
I'd just like to clarify real quick. You're saying if anyone has cross-examination for Mr. Lovejoy, is that correct? Or for rebuttal?
So I had intended to call Mr. Lovejoy to stand for questions relating to the discovery responses that he had sponsored. So that was what I was going to call him for. And then there is the possibility that he might be necessary on rebuttal, depending upon how the proceeding unfolds.
Yeah, and I think we just entered all those data responses. So I think maybe for purposes of rebuttal,
Sure, but
That's-
I don't know if anyone has questions about that. That was why he was, in the same way the Northwestern witnesses are available for questions. That's what the intent is.
yeah, that's fine with us.
So yes, Mr. Lovejoy is permitted.
Thank you.
Thank you very much. Okay. So let's proceed to opening statements. Would Petitioner Kelp like to make an opening statement?
Yes, thank you.
Sorry,
Oh, pardon me, sir.
Chairman O'Donnell, we also had a request to allow Mr. Patrick Powers to present live
Oh.
direct testimony and I've consulted with Kelp's attorney. He didn't have an objection. Is there any objection from anyone else?
Seeing no objection, so approved.
Thank you.
Mr. Nelson.
Thank you. And Mr. O'Donnell, just so I don't screw this up, do you prefer in the course of this that I address you as Mr. Chairman or Mr. President? Not sure what the right answer to that question is at this point.
I am inclined towards great informality, but Mr. Chairman will do.
Excellent. Thank you, Mr. Chairman. Good morning again. As I indicated during my entry of appearance, my name is Thor Nelson. I'm with the law firm of Holland and Hart, and I'm here today representing the petitioner in this proceeding, the Colstrip Energy Limited Partnership, or KELP. On behalf of KELP, I'd like to thank the chairman and the commissioners for your time and consideration to these issues that are so critical for KELP, as well as Northwestern and Northwestern's customers. The case before us today involves the Rosebud Power Plant Project, or KELP. KELP is a qualifying facility under the Public Utility Regulatory Policies Act of 1978, which means that under federal law, as executed by this commission, KELP has a right to interconnect with and sell power to Northwestern Energy at avoided cost rates and under such other terms and conditions as may be determined by you, the Montana Public Service Commission. KELP is located near Colstrip, Montana. The evidence will demonstrate through the course of this proceeding that there are two main differences between KELP and most QF projects that the commission may be familiar with. First, unlike most QF projects, the KELP QF has been in commercial operation since May of 1990. During those past 30+ years, KELP has operated with a maximum output of 42 megawatts net of parasitic load used at the plant, and has, year over year, consistently delivered an average of 35 megawatts of annual capacity and the associated energy to the Montana Power Company and now Northwestern Energy, in accordance with the power purchase agreement between those various parties. Second, unlike most QFs that you see these days, KELP is not a renewable energy project. KELP's fuel source is a coal refuse product, or what is sometimes also called waste coal. The waste coal is a byproduct of the mining operations of the Western Energy Company at the nearby Rosebud mine. As the commission is well aware, that mine also supports the Colstrip power plant with higher quality coal that the mine produces. KELP, it will be proven, is an established, reliable resource for Northwestern's customers. Approximately 30 people are employed to operate and maintain the KELP facility. In our petition in this proceeding, the KELP QF is asking the commission to establish rates, terms, and conditions under which we can interconnect with and provide electricity to Northwestern, because KELP's current QF power purchase agreement is set to expire on June 30th, 2024. This request includes asking the commission to set both the energy and capacity components of KELP's avoided cost price, as well as approving other non-rate terms and conditions in the PPA, and approve appropriate interconnection terms and conditions to ensure the project can continue to interconnect with Northwestern Energy. Under PURPA, importantly, all of these issues are to be decided by this commission and not by FERC. Relative to the interconnection issues, I'll just note here at the onset a somewhat unique characteristic of the currently effective PPA. The existing PPA was executed before the modern interconnection rules went into effect. By that, I mean, at the time the existing PPA was executed, there were no standard large generator interconnection procedures, and there was no pro forma large generator interconnection agreement. Because of this, the existing PPA that KELP has with Northwestern also continues to contain, as we propose, the interconnection terms and conditions. As we sit here today, there is no separate standalone interconnection agreement between KELP and Northwestern. Having highlighted those general requests, I'd like to talk a little bit about why we are here in a contested case instead of bringing before you a negotiated agreement. The evidence will show in this proceeding that for years, Kelp has made it clear to Northwestern that it would like to extend its existing PPA and continue to offer service to Northwestern and its customers for as long as the Colstrip power plant continues to operate. For years, Kelp has attempted to negotiate an extension. However, Northwestern has consistently rejected Kelp's proposed terms, and in more recent years has told Kelp that under an unwritten policy, Northwestern will not negotiate with an existing QF until that project is within 6 months of the expiration of its existing PPA. Kelp's witnesses will explain how delaying negotiations until 6 months prior to the expiration of the PPA is untenable. Kelp must have an understanding of its future revenue streams in order to plan for capital investments and provide its employees with the assurances that they need that their employment is secure going forward because the project will continue in commercial operation. The evidence will further show, and it should be noted by this commission, that while Northwestern refused to negotiate with Kelp until 6 months before the expiration of the existing PPA, Northwestern was in fact negotiating with a variety of other renewable resource qualifying facilities that are still under development and therefore are unproven, uncertain resources. In the face of Northwestern's refusal to negotiate, Kelp felt compelled to file the petition in this proceeding. Based on that petition, let's now turn to some of the main issues that will be before the commission will be discussing over the course of the next several days. The evidence will show that Kelp's proposed PPA, or power purchase agreement, utilizes variable energy rates that are consistent with the commission's rules. Specifically, Kelp proposes that the energy payments from Northwestern to Kelp be based on the metered kilowatt hours delivered to Northwestern, multiplied by the specific locational marginal price, or LMP, hourly price measured at the nearest liquid market node, which is the node at nearby Colstrip. But for Kelp's existence, that is the nearest node where Northwestern could reasonably expect to receive energy and capacity to serve its needs. Kelp also proposes that the LMP price be based on day-ahead pricing instead of real-time pricing as recommended by Northwestern and the Consumer Council. That is to help Kelp make informed decisions about when and how to operate, as opposed to being forced to schedule power a day ahead without knowing what price that power will be sold at. Next, I'd like to talk about the avoided cost component that relates to capacity. Kelp's recommended rate for capacity provided from the project, as updated in Mr. Gorman's rebuttal testimony, is $27.93 per kW month. Kelp proposes that this rate be applicable throughout the term of the extended PPA. Now, there are several aspects of the capacity rate that Kelp and Northwestern and the MCC disagree on, but the most significant one, which I will start focusing on, is whether a capacity payment is warranted at all based on Northwestern's existing pool of resources and expected resources in the future. Northwestern has suggested through their testimony that there is no capacity need that Kelp would otherwise serve until 2032, based on the methodology for analyzing capacity need that is proposed to be used by the Western Resource Adequacy Program, or WRAP. This approach should be flatly rejected by the commission. The evidence will show that the WRAP is a FERC jurisdictional program that has yet to be approved. Furthermore, whether and the extent to which Northwestern and other utilities will participate in the WRAP is also uncertain at this time. As we sit here today, we have no idea if the FERC will approve the WRAP, and if it does, we have no idea who might sign up for the program or how that program might actually work going forward. Finally, notwithstanding Northwestern's testimony in this case that they have no capacity need until 2032 that Kelp would otherwise fill, just 2 months ago, Northwestern announced that it was going to be conducting a new RFP in 2023 for new capacity to be available in 2026, 6 years prior to the 2032 date they testify in this proceeding. Rather than using the WRAP methodology as recommended by Northwestern, the commission should use its longstanding ELCC, or effective load carrying capacity methodology, to determine whether and the extent to which Northwestern is capacity short, and whether and the extent to which, as a result, it is appropriate to provide a capacity payment to KELP starting in 2024. The ELCC methodology is a methodology the Commission is well familiar with. The Commission has approved this methodology in the past for other QFs and for use in Northwestern's resource planning. The evidence will show that under the ELCC methodology, there is a clear capacity need for KELP in 2024 and beyond, a need which the evidence will show is made all the more clear given the recent cancellation of the Beartooth Battery Storage Project, a project coincidentally very close in size to KELP. Further, the evidence will show that the price for the capacity should be based on the cost of a proxy resource comparable to the cost of a new unit at the Yellowstone County Generating Station, or YCGS. Try not to use that acronym, it's hard to say. Or at least based on a proxy resource comparable to the cost of a new unit at the Dave Gates Generating Station, but where that includes the necessary investment and expenditures that are needed to ensure the firm delivery of natural gas to such a resource. Basing a capacity price on a resource with an interruptible fuel source that can, during peak periods like we saw during Winter Storm Uri, be interrupted and thus be unavailable simply makes no sense. Relative to the capacity payment issue and the PPA in particular, the evidence will also show that if the Commission agrees with KELP that the ELCC methodology is the correct methodology, that Northwestern's testimony concedes that its entire PPA pricing structure, which depends upon the RAP methodology for the term of the contract, cannot work and will not be applicable. That conversation segues nicely into a discussion about the other various terms and conditions in the PPA, which are subject to the course of the hearing today and in the days ahead. In rebuttal, KELP accepted many of the terms and conditions in the Northwestern PPA, which KELP believes are appropriate for an existing project with a proven track record. However, there remain many terms and conditions in Northwestern's proposed PPA that are not applicable to a new project and not to an existing project with a long history and proven track record. The existence of those terms, if they were to be approved, place unreasonable and unnecessary financial burdens on KELP, and as such, they should be rejected. Finally, as I mentioned at the beginning of my opening statement, the existing PPA between Northwestern and KELP is somewhat unusual in that it contains interconnection terms as well as the terms for the sale of energy and capacity. Again, KELP currently does not have a standalone interconnection agreement. As a result, KELP asked the Commission in this proceeding that you use your authority under PURPA to order Northwestern to continue to interconnect with the project after the expiration of the existing PPA. Additionally, KELP recommends that the relevant interconnection terms and conditions that are within the existing PPA be included and incorporated into the new PPA to allow for a seamless transition. Alternatively, in the event the Commission prefers to have a standalone interconnection agreement, KELP recommends an interconnection agreement that we developed based on the approach used in Idaho for Idaho Power. In Idaho, Idaho Power has an approved QF interconnection agreement, and it applies with terms and conditions that are applicable for an existing project like KELP. The evidence will show, conversely, that Northwestern's proposed large generator interconnection agreement is simply the standard pro forma agreement that is not tailored for a QF and that contains terms and conditions that exclusively apply to projects under development and not to existing projects. Finally, in the context of interconnection, KELP asked the Commission to order that KELP not be required to undergo any further interconnection studies or participate in any further interconnection processes, but simply to continue the existing interconnection arrangements as they have been doing for the last 30 plus years. Northwestern has admitted, and the evidence will show, that if the point of interconnection doesn't change, and there is no material modification to the project, no interconnection request is required, and the existing interconnection facilities can continue to operate as is. But there is also a dispute about what the interconnection capacity is under those existing interconnection arrangements. Northwestern asserts that the interconnection capacity available to KELP is somehow limited to 35 megawatts. The evidence will show that that is wrong, that as a matter of law and contract, the interconnection facilities that are currently in place have been and have always been sufficient to accommodate the entire output of the plant up to a full 42 megawatts. And there is no basis for the commission to artificially limit the interconnection rights of KELP to 35. In total, relative to the interconnection arrangements and issues, KELP requests that the commission not entertain Northwestern's efforts to place unnecessary and burdensome hurdles in front of KELP's ongoing right to interconnect, and that the commission simply order Northwestern to continue interconnection in the manner that has been done for the last 3+ decades. In support of all of these positions that I've talked about this morning, KELP anticipates calling for witnesses. First, KELP will call Mr. Michael Gorman of Brubaker and Associates. Mr. Gorman will testify regarding the history and background of KELP, the history of the negotiations with Northwestern, appropriate avoided cost pricing and the pricing methodology, as well as the terms and conditions of an appropriate PPA between KELP and Northwestern. Next, KELP will call Mr. Brian Collins, who is also of Brubaker and Associates. Mr. Collins will testify regarding the various interconnection issues before the commission in this proceeding and explain why the existing interconnection arrangements continue to make sense for KELP and Northwestern. Mr. Collins will also offer a proposed interconnection agreement, again, in the event the commission prefers to separate the PPA and the interconnection into separate documents. Next, KELP intends to call Mr. Owen Orndorff, the Vice President and General Counsel of Rosebud Energy Corporation. Mr. Orndorff will stand to answer questions from discovery relating to the history of KELP's operations and relationship with Northwestern over the decades, essentially discovery responses, which he indicated that he was available to answer questions on. Finally, KELP will call Mr. Bill Lovejoy. He's a chief engineer at the NACE Corporation. Mr. Lovejoy will also address questions relating to discovery about some of the technical aspects of KELP's project and interconnection and how those relate to the terms and conditions of the interconnection agreement. Mr. Lovejoy may also be called in the hearing to respond to potential live testimony from Mr. Patrick Powers of Northwestern that was discussed earlier today. KELP appreciates that these are complex issues and pose challenges to the commission and its staff to navigate. We appreciate the commission's time and attention to these critical points, and we urge the commission ultimately to adopt avoided cost and interconnection rates, terms, and conditions that are consistent with Montana law and precedent so that KELP can continue to provide reliable coal-fired generation to Northwestern and its customers as long as possible. Thank you.
Thank you, Mr. Nelson. Would intervener Northwestern like to make an opening statement at this time?
Chairman O'Donnell, may it please the commission. My name is Clark Hensley and I represent Northwestern Energy in this matter. It is vitally important for the commission to focus on what this case is actually about. This case is about protecting Northwestern's customers. It's not about providing financing for KELP. KELP is requesting the commission to compel Northwestern to contract with it under the Public Utilities Regulatory Policy Act of 1978, known as PURPA. PURPA requires Northwestern to purchase energy and capacity from qualifying facilities, QFs, including KELP. There's no dispute about that. However, PURPA does not require Northwestern to purchase at any rate that KELP demands. Northwestern's customers will ultimately pay for all the expenses Northwestern incurs from purchasing from KELP. PURPA protects Northwestern's customers by requiring this commission to set KELP's rates at Northwestern's avoided costs. Northwestern's avoided costs are the incremental costs that Northwestern would incur, but for purchasing from KELP. PURPA keeps customers indifferent by limiting rates to Northwestern's actual avoided costs. Northwestern will present pre-filed testimony from witnesses that actually plan and operate Northwestern's system. Northwestern's testimony presents Northwestern's actual avoided costs based on its witnesses' personal firsthand knowledge of planning and operating Northwestern's system. Northwestern proposes a proposed power purchase agreement and a large generator interconnection agreement in LGIA that are as consistent as possible for all QFs, which maintains an even playing field. KELP, on the other hand, will present pre-filed testimony from outside consultants without any actual firsthand experience planning for or operating Northwestern's system, or KELP system for that matter. KELP did not present any pre-filed testimony from a single witness from within its own company. KELP also presented a proposed power purchase agreement and interconnection agreement that would provide special treatment for KELP that no other QFs receive and that no other generators receive. Throughout this case, I intend to show you that over and over again, KELP continually attempts to inflate its rates above Northwestern's avoided costs. Those inflated rates would directly harm Northwestern's customers. KELP also recommends an interconnection agreement that has not been approved by any regulatory commission. That agreement does not require KELP to follow the same rules that every other generator and every other QF must follow. It's convenient for KELP, but it's harmful to Northwestern's customers. Northwestern's witness, Mr. Stephen Schmidt, will detail exactly how Northwestern determined its avoided cost of capacity. He will identify the resources in Northwestern's portfolio and explain why those resources must be included. He used the exact same method that this commission previously approved in the Caithness docket. Mr. Schmidt will explain why the commission should use the Western Resource Adequacy Program's capacity accreditations and the reserve margins to determine Northwestern's capacity needs. The program is referred to as the RAP. The RAP methodology provides the best reflection of Northwestern's capacity needs throughout the course of KELP's contract for avoided cost purposes. Because Northwestern is committed to the RAP and will receive the benefits it provides throughout the course of the contract. As Mr. Schmidt will describe, it's vitally important for the commission to recognize that Northwestern's capacity need for purposes of avoided costs using the RAP is fundamentally different than it is for its resource adequacy analysis. Northwestern needs capacity for resource adequacy. That's entirely different than avoided costs. For avoided cost purposes, Northwestern must determine the increment of capacity that KELP will satisfy in relation to other QFs in Northwestern's portfolio, including those that may claim a legally enforceable obligation date in LEO ahead of KELP. Including those QFs for avoided cost purposes renders Northwestern capacity sufficient until 2032. Northwestern has no control over when a QF establishes an LEO, but it must include QFs in its portfolio on the date they satisfy this commission's criteria. Otherwise, multiple QFs could be determined to satisfy that same increment of capacity, and Northwestern's customers would have to pay for that same increment of capacity multiple times. It's like water rights in the West. First in time is first in right. The QFs with the earliest LEO date get to satisfy that first increment of needed capacity. And just like whiskey is for drinking and water is for fighting, numerous QFs, including KELP, are fighting for that same increment of capacity that others have essentially claimed. This is QFs versus QFs. This is not Northwestern versus QFs. The only way Northwestern can protect customers is to include the QFs in its resource portfolio when they satisfy this commission's rules. Mr. Schmidt will also explain that the RAP's rolling capacity accreditation should govern KELP's capacity payments in the years that Northwestern is projected to need capacity from 2032 forward. Mr. Schmidt will also explain that the appropriate proxy to determine KELP's capacity rates is the least cost resource in Northwestern's 2019 plan. That resource is a 50 megawatt aeroderivative at Dave Gates Generating Station. That is also the same 50 megawatt aero that this commission has consistently approved in prior QF dockets. The Yellowstone County Generating Station is already under contract and being built, and it is not an appropriate proxy as Kelp proposes. Kelp will not allow Northwestern to avoid the costs of the Yellowstone County Generating Station. Mr. Smith presents Northwestern's power purchase agreement in this matter, which maintains consistency with power purchase agreements that this commission has previously approved for QFs and deviates only to the extent necessary to accommodate Kelp, providing an equal playing field without unnecessary specialized treatment. Mr. Quinn McCarthy will present Northwestern's proposed energy rates based on Kelp's own locational marginal pricing node, the Rosebud node. He will explain how the Western Energy Imbalance Market's locational marginal pricing works and why the Rosebud node provides the best reflection of Northwestern's avoided costs by purchasing from Kelp. He will also identify why the commission must approve real-time rates at the LMP and not day-ahead rates as Kelp proposes. Northwestern does not even have access to a day-ahead market. Mr. McCarthy also points out how Kelp has attempted to inflate Northwestern's avoided costs. Mr. Michael Bobineau will present Northwestern's avoided capacity rate of $18.87 per kilowatt month based on the same type of revenue requirement that this commission has previously approved in QF dockets. Ms. Autumn Mueller will explain why Kelp must execute an LGIA following the termination of its existing agreement. She will request the commission to approve Northwestern's standard form LGIA for Kelp and require it to engage in Northwestern's interconnection process. This is the same standard form LGIA and same process that Northwestern requires for all generators, even existing generators, and the same LGIA and the same process that this commission has consistently required for QFs. Mr. Patrick Powers will explain the operational difficulties Northwestern has experienced due to Kelp's failure to follow standard requirements for voltage, reactive power support, and frequency response, and the impacts that Kelp's refusal to follow those requirements has had on Northwestern's customers. He will explain how the LGIA will require Kelp to follow those standards, the same standards Northwestern requires for all generators and for all QFs. Kelp should not receive any special treatment, especially when that special treatment is detrimental to Northwestern's customers. Northwestern's confident that its proposal represents its actual avoided costs and protects customers from overpaying Kelp. Northwestern's proposal also provides consistency and a level playing field for all QFs. After considering all the evidence and argument in this case, Northwestern will respectfully request the commission to adopt its proposal. Thank you.
Thank you. Would intervener Montana Consumer Council wish to make an opening statement?
Mr. Chairman, may I reserve?
Mr. Nelson, would you care to proceed with your case in chief?
Thank you, Mr. Chairman. Kelp would call to the stand Mr. Michael Gorman.
At this point, I would like all of today's witnesses to please stand. Raise your right hand and I will swear you all in at once. Do we have any witnesses online at this moment?
Yes.
No, okay. Do you swear the testimony you're about to give is the truth and nothing but the truth?
Yes.
Thank you. This says, counsel, if any of your witnesses are not present today, please notify me now at the time your witnesses are called to testify so that I may swear them in at that time. See.
Very good. Thank you. Good morning, Mr. Gorman.
Good morning.
Mr. Gorman, would you please state and spell your name for the record?
My name is Michael Gorman, Gorman.
And by whom are you employed and in what capacity?
Employed by Brubaker and Associates as a managing principal.
And on whose behalf are you testifying today?
Kelps. Full Strip Energy Limited Partnership.
Mr. Gorman, did you cause to be pre-filed in this proceeding testimony on behalf of Kelp?
Yes,
So first, am I correct that you caused to be pre-filed direct testimony and exhibits?
yes,
Then you also caused to be filed corrected rebuttal testimony exhibits?
I did. Yes,
Do you have any further corrections to your rebuttal testimony that you would like to offer today?
I do. Yes, there's some typographical errors in the testimony I'd like to correct.
If it please, Chairman, I'd like to ask the witness to go through those errors and corrections at this time.
Hey, I apologize. There are several of them.
Mr. Gorman, if you would just proceed and slowly note the changes that you would offer today.
Thank you. On page 11 of my rebuttal testimony on line 5, the words preceding 20 megawatts says up to, that up to should be struck and above should be inserted. On page 18, line 21, the word electric right before the word load should be deleted and effective should be inserted. On page 22, footnote 27, the page number reference SIS 18 should be expanded to SIS 17 and 18. On page 23, footnote 28, exhibit MPG 8 should be expanded to include page 7. Page 26, line 7, calendar year 2024 should be struck and 2022 should be inserted. On page 34, footnote 22, docket number 2202 should be struck and 2022 should be inserted. On page 36, footnote 40, ID should be struck and in its place, pre-filed McCarthy intervenor testimony at QMM-11 should be inserted. And on page 49, footnote 45, prior to the page QMM-6, pre-filed McCarthy intervenor testimony should be inserted. That completes the corrections.
Mr. Chairman, prior to the hearing commencing, I asked Mr. Gorman to make those changes manually in the copy of his testimony that was provided to the court reporters. So that is in the commission's possession at this point. And then finally, Mr. Gorman, I've placed before you what's been marked for identification as Exhibit Kelp 1. Do you recognize that?
I do.
And what is that?
It's a petition to set terms and conditions for a qualifying power production facility.
And is that the petition that commenced this proceeding, as you understand it?
It is, yes.
And did you participate in the creation of that petition?
I did, yes.
Mr. Chairman, I'm curious as to how you would like to proceed. So at this point, I would intend to offer as Kelp exhibits the petition and Mr. Gorman's testimony. The ordinary course, I would offer those as exhibits Kelp 1, Kelp 2, and Kelp 3. Is there anything changed about the process since I was here last in person that I should be aware of and not do it that way?
No changes.
Okay, excellent. Then I'll start by moving the admission of Kelp Exhibit 1, which is the petition to set terms and conditions for a qualifying small power production facility pursuant to MCA Section 69.3.603.
Any objections?
No objection.
So moved.
And I'll offer the exhibit Kelp 2, the testimony exhibits of Michael Gorman on behalf of Kelp filed August 5th, 2022.
Any objections?
I'm gonna make a standing objection. I think it'll apply to both sets of testimony. Instead of doing it twice, is it okay to wait until after the next set is presented?
Mr. Chairman, Mr. Hensley, for the clarity of the record, we can, I think, accommodate either. This is a standing objection to just Mr. Gorman's two sets of testimony, or is it all testimony?
It would apply to all testimony. I can make it when Mr. Collins comes up too.
In that
whatever you
case,
prefer.
Mr. Chair and Mr. Hensley, I'd recommend making the objection with each witness.
Yeah, that's fine. Mr. Hamilton, he also has rebuttal testimony that they're about to offer. Do you want to make that objection now to cover his direct and rebuttal, or do you want me to wait till after they offer their rebuttal?
Mr. Chair and Mr. Hensley, I would propose that we wait until we have a motion to admit and then lodge the objection.
I just moved to admit exhibit 2.
And for clarity, exhibit 2 is
Direct testimony.
only the direct testimony.
If it will make life easier, why don't I also move to admit exhibit Kelp 3, excuse me, the corrected rebuttal testimony exhibits of Mr. Gorman. I'll move them both simultaneously.
Thank you. Yeah, Northwestern just wants to make a standing objection to the extent there's any legal conclusions or argument presented in either testimony consistent with its motion in limine. We don't believe that it's appropriate for witnesses to render legal conclusions. I'd also like to object with respect to the rebuttal testimony to the extent that Kelp attempts to rebut its own proposed LEO date. Kelp proposed an LEO date in this matter of April 29th, 2022. Nobody opposed it. And then on rebuttal, Kelp's now attempting to say they established an LEO earlier than that. I don't believe that's an appropriate use of rebuttal. And I just want to make a standing objection on the record for that.
At this time, I'll overrule the I rule then helps exhibits 2 and 3 be admitted.
With that, Mr. Chairman, I have no further questions at this time of Mr. Gorman. He's available for cross-examination and questions from the commission.
Hensley?
Thank you. Good afternoon. It's nice to meet you in person.
Good afternoon. Morning.
My bad. You're right.
Afternoon somewhere.
Have you ever been cross-examined before?
I have, yes.
So you know the process.
Do, yes. Okay. Yes, I have.
So I'm going to ask you a series of questions that call for yes or no, or simply a confirmation like that's right or that's correct. You had over 100 pages of testimony and I have a lot of questions for you. So for the sake of keeping us all on pace, I'd appreciate just those short yes or no or confirmation type responses so we can get out of here in a timely manner. If I want you to explain, I'll ask you to. If I do ask you an open-ended question, please feel free to elaborate, but I'll try not to so we can stay on pace here. Is that okay?
Do my best.
So first of all, what you have in front of you is your pre-filed testimony and exhibits. Is there anything else?
I have a notepad and just some notes, some of the arguments that have been going back and forth.
Okay. And before I get to your testimony, I just want to confirm you've never operated Northwestern System, right?
Correct.
And you've never conducted planning for Northwestern System?
I've responded to planning of Northwestern System, but I have not worked for Northwestern. No.
Yeah, you've never actually done the planning for Northwestern.
Correct.
Okay, so we'll start with, I'm going to do it in 2 tranches here. We'll start with your pre-filed direct testimony. Okay. Kelp's capacity rates should not exceed Northwestern's avoided costs, right?
That's my testimony.
Determination of avoided costs must focus on Northwestern's costs, not Kelp's, right?
Correct.
And you propose the commission to set Kelp's capacity rates based on the cost of the Yellowstone County Generating Station, right?
Yes.
Northwestern executed a contract for the engineering and procurement and construction of Yellowstone County Generating Station in April of 2021, right?
I have to check that date, but that's approximately my understanding.
Northwestern provided full notice to proceed under that contract in December of 2021, right?
Again, I would have to verify that, but it's generally consistent with my understanding.
The Yellowstone County Generating Station is currently under construction, right?
That's my understanding.
Will Kelp allow Northwestern to avoid the costs associated with the Yellowstone County Generating Station?
Doesn't need to, and it will not. No.
Right, so it will not allow Northwestern to avoid the costs of the Yellowstone County Generating Station.
It will not. The Yellowstone Generating Station will not meet all the capacity requirements Northwestern requires.
That's not the question I asked you. I just want to make sure we're understanding. Purchasing from Kelp will not allow Northwestern to avoid any of the costs associated with the Yellowstone County Generating Station. Yes or no?
I agree with that.
Okay, but to be clear, you still used Kelp as the proxy, you still use the Yellowstone County Generating Station as the proxy for your capacity rates, right?
Because it is Northwestern's marginal capacity cost for a unit being installed in 2024. And it does not meet the full capacity requirements of Northwestern in that year.
We'll get to that. But again, you used a proxy, that cost of a proxy that Kelp will not allow Northwestern to avoid.
I stand by my prior answer.
And that was it wouldn't.
Correct.
In your direct testimony, you increased your proposed capacity rates by 2.8%. Is that right?
There was a step-up voltage adjustment equal to 2.8%, yes, to reflect Kelp's cost of delivering energy to the high voltage meter.
Okay, so we'll get to that. And that, I think you just said it though. Those were Kelp's costs, right?
They are Kelp's cost, yes.
And didn't we just establish that avoided costs must be based on Northwestern's costs, not Kelp's?
Well, they are based on the avoided cost of generating for Northwestern. Northwestern at Yellowstone also will produce electricity at a generation voltage and have to step that voltage up to deliver it to its balancing authority.
But you just said that that 2.8% was to accommodate Kelp for losses, for its own losses between its generation and the point of interconnection, right?
Well, I don't know if I refined it quite like you're characterizing, but it reflects the cost of a new generating unit producing electricity at about 13.8 kV and then going through a transformation process where that generation is metered at a bulk transmission voltage of around 115 kV. So that would be true for Kelp, it'd be true for Yellowstone, it'd be true for Dave Gates.
They all have that same setup?
Well, they all have step-up voltage transformation adjustments.
Okay, so let's talk about that too. So can you show me in your direct testimony where you said anything about a voltage step-up losses?
It's characterized as a transmission loss based on Northwestern's transmission loss study in its rate case.
Right.
Transmission loss factor is based on loss of power from generation level up to the balancing authority, which I think generally characterizes the Kelp arrangement and also the arrangement of Yellowstone and Dave Gates.
You represented that those losses were for transmission losses, right?
It's termed transmission loss, but the measurement of the loss starts at generation facility, which is at a generation voltage. It generates, for Kelp about 13.8 kV. Then that generation has to be stepped up to the bulk transmission system, which ranges from 115 up to 500 kV in Northwestern system. There is a loss in that voltage transformation process that is part of the cost of the generating units delivering power to the balancing area authority for Northwestern.
Are you aware that Northwestern's customers are already charged for transmission losses?
Yes, because it represents a real cost to either Northwestern when producing energy itself or to having power delivered to its system, which would include transmission charges for Northwestern's delivery system as well as delivery systems across other transmission systems.
So if customers are already being charged for transmission losses, your proposal would have double charged customers for those losses then, right?
It's not a double charge. What it is a price for the output of kelp. And it's already in your balancing authority, so it is at transmission level voltage.
If customers are already charged for transmission losses reflective of that 2.8% in the costs that Northwestern's power costs and PCAM rates, Northwestern would be, but no, customers would have to pay that 2.8% already, right?
Not if the power is already delivered to the bulk transmission system, the balancing authority for Northwestern, that represents the loss adjustment that is included in Northwestern's cost of service. The question is who should receive recovery of that cost? Should it be the generator, which in many cases is Northwestern, but in this case is a kelp, which is also incurring costs associated stepping up the voltage from its generating unit up to the balancing authority bulk transmission system for Northwestern.
You're saying that there should be a 2.8% increase to kelp's rates in the PPA, right?
And the price of power delivered to the BAA or balancing authority area for Northwestern, yes.
Right.
Which
So
is consistent with what you do for your generating facilities.
are you aware how Northwestern collects the costs it pays customers?
They allocate costs across customers at a transmission level delivery voltage, and then there is distribution related step down voltage adjustments to each of the various rate classes.
Customers pay for everything that Northwestern will pay kelp, right?
Yes,
And that would include the 2.8% in the contract itself.
that would be the price, yes.
And customers also pay power costs and credits adjustment mechanism rates that has transmission losses included in it, right?
And that would be what you pay kelp. That would be what you should seek recovery from your customers for.
That's not if Northwestern also charges them customers for 2.8% for its transmission losses in the PCAM, and you also have 2.8% included in the contract, customers would be paying that 2.8% twice, right?
Northwestern shouldn't charge for a loss. If the power is already delivered to your balancing authority, Northwestern will be imposing a cost on customers. It's not entitled.
That's not the question I asked you. The question I asked you is if they're already included in the rates and they're also included in the contract, they'd be paying them twice.
They should not be included in the rates.
That's not what I'm asking you. Is if they were both in both places, they would pay them twice, right?
Well, then Northwestern, yeah, they would, and Northwestern be recovering a cost they're not entitled to.
Well, the PCAM rates aren't an issue here today, so let's move on. In your direct testimony, you levelized the cost for the Yellowstone County generating station over a 15-year period, right?
In my direct testimony, that's correct.
Okay. That increased the proposed rates compared to if you had used 18 and a half years for the contract term, right? All right. That increased your proposed rates using 15 years, increase your proposed rates compared to if you had used 18 and a half years.
I don't know if it did, because after 15 years, there's two components of the rates. One's the capital cost, the other is the fixed O&M. After 18 years, the capital cost becomes less of the revenue requirement, and the fixed O&M that's being escalated for inflation becomes more. So going out 18 years, I think there's a bit of a trade-off. So that was my expectation when I filed my direct testimony. It was a long-term contract. We went back and forth on the term of the contract for a while. But generally speaking, I would expect there be a slightly lower rate with 18 and a half year levelized cost recovery compared to a 15-year, but I don't think it would be significant for the reasons I just described.
Right, but it would be more.
It might be, it may be more, and if it is, it might be slightly more.
And if you'd used the full 30 years useful life of the Yellowstone County Generating Station, it would have been even lower, right?
It would have, but that's because you would not be accurately measuring NWE's cost of capacity during the term of the QF contract.
I'm talking about how you calculated your revenue requirement. If you'd used 30 years compared to 15, it would have been even less, right?
It would have for the reasons I just explained.
And you also use 165 megawatts as the accredited capacity for the Yellowstone County Generating Station. Is that right?
Yeah, based on the company's representations, that's correct.
And that's the denominator in your equation, right?
It is, yes.
And so if we increase that denominator, rates would be even less.
The revenue requirement stayed constant, yes.
And if you had used 170 megawatts, your proposed rates would have been lower, right?
It would have.
Do you agree that the value of capacity is directly related to being able to plan for that guaranteed availability?
Can you repeat that question, please?
Do you agree that the value of capacity is directly related to being able to plan for a guaranteed availability?
Well, the ability to rely on that capacity to meet your resource capacity obligations is important in assessing the reliability of the capacity. And to the extent the cost relates to that, the value of that resource capacity, I would agree with that.
Okay. Northwestern needs to count on having a firm guaranteed commitment for capacity planning, right?
I don't know if they have that in their resource plan based on the ELCC methodology. That's my understanding of how they're planning their resources. Yes.
But yeah, regardless of which methodology we use to figure that out, we need to have a guaranteed commitment from a resource in order to include its capacity for planning purposes, right?
Well, under the RAP methodology, I don't know if that meets the same standard because of the uncertainty of implementing the RAP and whether or not Northwestern Energy will actually join the RAP after the
I'm not talking about the RAP.
non-binding.
Excuse me. I'm not talking about the RAP.
But
I'm talking about in order to plan for capacity, Northwestern needs a commitment from a resource that it's going to be able to produce at a certain level in order for Northwestern to use that to serve load, right?
to answer that question, I have to make assumptions on prudent planning principles.
Well, capacity must be planned in advance, right?
Yes,
How far in advance?
far enough so the resource is available and in service at the time you need the capacity.
Well, doesn't it have to be far enough also so that Northwestern can obtain other resources if it's not currently able to serve its load?
For example, if it needs more than one resource in 2024, it needs to plan for more than one resource in that year to ensure it has sufficient resources to meet its loads.
And that takes time, right?
It does take time.
Okay. How much more than a day?
Now, it depends on whether or not a contract is made available to the utility that would provide a reliable resource in the future, in which case it could take a day if Northwestern negotiated for that supply agreement. If it's a new resource that has to be developed, where transmission infrastructure has to be designed and constructed, where the generation resource itself has to be designed and constructed, where gas supply or fuel supply for the resource has to be arranged for, it can take years for the planning to put that in place.
Right. And so prudent planning, you wouldn't want to plan to serve all your load in one day, right?
Again, if there was a reliable purchase power agreement where a contract was offered to you, you could negotiate that in one day.
Is that realistic?
If you negotiate it, I don't know, but it could happen. I don't know the likelihood that it would happen.
Okay. And your proposed PPA says that KELP receives full capacity payments if it satisfies its monthly capacity commitments, right?
Seasonally adjusted and averaged over the various seasons. That's correct. It has to perform in order to fully be paid the capacity payments under the contract. And the performance objectives are quite onerous on KELP.
We'll get there. On page 4 of your direct testimony, you say Kelp will be obligated to deliver 32 megawatts of capacity during peak load hours during the summer, right?
Yes,
And 37 megawatts during the other months?
correct.
On page 6 of your direct testimony, you say that under the proposed power purchase agreement, Northwestern would have a right to firm capacity during on-peak periods so it can meet its native peak demands, right?
Yes,
And you go on to say that during peak periods, Kelp must deliver the minimum capacity obligation, right?
the 32 megawatts or 37, depending on the season.
Okay.
On average over the term of the season.
Yeah, so let's get to that. So your actual proposed PPA only requires Kelp to provide an average availability, right?
I don't know if our contract specifically specifies an availability. It clearly specifies a pricing structure, which encourages Kelp to provide as much capacity and energy as economically possible, with an obligation for Kelp to meet its commitment to the contracts and an average capacity delivered to Northwestern in the summer and non-summer periods.
Yeah, an average during the summer of 32 megawatts during peak hours, right?
Yes,
So you're saying Kelp could provide 22 megawatts during half of those peak hours and 42 megawatts during the other half and still receive a full capacity payment?
well, I haven't done the math on that but they certainly can vary the amount of capacity delivered on an hourly basis through those peak hours, yes, and meet its capacity obligations.
Well, let's talk about it. So your current contract says that Kelp can operate up to 42 megawatts, right?
It will deliver 42 megawatts during the summer period.
And it's committing to an average of 32 megawatts, right?
It has I'm sorry, I misspoke before. It is a 42 megawatt net generation resource where it's committing to deliver 32 megawatts on average during peak hours during the summer period.
The difference between 42 and 32 is 10, right?
Correct.
And 32 minus 10 is 22, right?
Yes,
Okay, so are you saying Kelp could provide 22 megawatts during half of the peak hours and 42 megawatts during the other half and still receive full payment?
I suppose you could, if there's a need for some limitation on that, but I haven't done the math, but presumably that's a possibility under a simple arithmetic exercise. The question is whether or not there'd be in Kelp's economic interest to do that.
Well,
And based on the historical performance and what's expected into the future, their behavior like that would be economically illogical.
But your contract does say average, right?
It's because it's putting performance standards on Kelp to
That's
ensure delivery of the power. But you can create a scenario where we would meet our capacity obligations and those extreme conditions.
Right. And did you use the word average when you're referring to your capacity, the capacity commitments
Gentlemen,
Kelp's going to?
It seems that we have lost connection with Commissioner Fielder. Could we take just a moment pause for her to reconnect? We'll do a 5-minute recess. Time is now 10:09.
Or for having a hard time.
Thank you. Got you so far.
I don't want to make a.
Long day. I think.
It's here live. This is a serious process improvement.
We'll be back on the record in 1 minute. We are back on the record. The time is 10:16. Mr. Hensley, you can may continue.
Thank you. Okay, Mr. Gorman.
Excuse me, before you start that, we noticed that for the discomfiture of the reporter right here, that there's been some over talking. So please wait until somebody is given their complete answer before asking the next question or responding. If you, thank you.
Yes, sir.
Thank you. Okay, so your actual PPA only requires KELP to provide an average, right?
Yeah, as we just walked through, it's based on performance obligations of KELP to provide capacity throughout the peak periods in the summer and non-summer periods. Yes,
And during the summer, that'd be an average of 32 megawatts.
correct.
And KELP can produce up to 42 megawatts onto Northwestern system under your proposal.
Not necessarily in the summer, but yes, it's rated at that low.
So theoretically, KELP could provide 22 megawatts during half of the peak hours, 42 megawatts during the other half, and still receive a full payment.
That's an extreme example, but that is mathematically correct. I could argue with you about the loss adjustment again, because the 3237 is measured in the balancing authority meter point, and the 42 megawatts is at the generator. But generally, it could vary it and still meet its minimum capacity obligation. Yes.
Yeah, so that 2242 is the highest fluctuation for averaging under KELP's proposal, where it could still receive a full capacity payment.
At the generator, not at the metering point. Correct.
So are you saying that KELP is only guaranteeing 22 megawatts during half of those hours?
It's not what I'm saying.
Well, if it can receive a full payment for providing an average of 32 megawatts, it could provide 22 during half of the hours and still receive a full payment.
It's not what I'm proposing.
Well, your contract says an average of 32, right?
It does, yes. It's a
Okay.
performance obligation on kelp.
And Northwestern wouldn't know which half of the hours Kelp would be providing 42 or 22 or any fluctuation in between that would provide an average, right?
Northwestern will know the delivery by hour from kelp. They'll know exactly what kelp is delivering,
How long in advance?
real time.
In real time. So you have to plan for capacity in real time.
Well, it's the same with any generation resources purchase power obligation. The amount of delivered power may be different than the rated capacity resource value.
But you're getting a capacity payment saying that you're going to be available up to 32 megawatts, right? Or not up to, at 32 megawatts.
But I mean, we structure the contract for performance requirements on kelp that would deliver 32 megawatts during the summer period, with the ability for kelp to deliver as much capacity as it can get out of the unit during that time period,
So
which often will be more than the minimum capacity deliverability.
under your contract, Kelp could still get a full capacity payment, but not provide 32 megawatts in all hours.
The structure of the average performance for capacity delivery, that's true, but that's really no different than any other capacity resource available to Northwestern.
Northwestern, do you agree that Northwestern must serve its load in all hours?
And it must rely on all of its resources to do that, which each resource may not deliver the contract capacity during every hour throughout the peak period.
Are you aware of any other contract Northwestern has that uses the word average?
Again, that's a performance structure for the kelp contract, so they're obligated to deliver. But I am aware that if a generating unit owned by Northwestern is not available during peak periods, it may deliver 0 megawatts during the peak periods.
That's not what I asked you. Are you aware of any contract for capacity Northwestern has that the other generator or selling party would only commit to an average?
Again, it's I'm not aware of that, but the structure of the kelp contract is to provide performance assurance to Northwestern from kelp and have kelp be paid for delivering consistent, predictable capacity throughout peak periods to Northwestern.
Do you agree that Northwestern should plan to serve its load in advance in all hours?
I do, but I mean, if you're looking for typically a peak demand is measured in a 15-minute increment. So if the contract were structured where kelp would receive a capacity payment for the peak delivery during those peak hours, that would be 15 minutes out of all the peak hours in the month. So kelp recognized the need for assurance of actually delivering capacity and energy to Northwestern under this PPA agreement. So we structured it so we don't get paid for capacity unless we're delivering capacity, and we're measuring that in all peak hours, not just the typical measurement of a 15-minute increment during the peak period.
Chairman O'Donnell, I'm trying to ask the witness questions that would require very short response. The witness is elaborating to the extent where we're going to be here for a very long time. Will you please instruct the witness to be more responsive to my questions?
It seems to me he is being responsive to your questions. I was wondering why you were asking him questions about the term average in Northwestern contracts that he couldn't possibly have personal knowledge of those contracts. So it seems to me your questions are a little bit unclear.
With all due respect, Commissioner O'Donnell, that we did produce contracts, and he could just say that he's not aware. And that's the point of the question.
If your question was, are you aware? That would be proper questioning. So I think that his answers are being responsive to your questions.
Well, I apologize if I didn't phrase the question that way, but are you aware of any contract that Northwestern has that uses the word average?
I have not reviewed your contract for that purpose. The reason we structured this contract that way is for the performance obligations.
Do you agree that Northwestern must plan to serve load in all hours in
Yes.
advance?
Yes,
And it can't plan in advance for a consistent 32 megawatts for under Kelp's contract because it's only committing to an average. Is that right?
I think that's part true, but I think the PPA, as we've structured it, Northwestern could ask Kelp to ramp up operations.
We'll get to the request. I'm saying as it's right now, that's true, right?
It's a capacity commitment with performance assurance. That's correct.
Performance assurance of only an average.
To ensure that capacity is delivered every hour of the peak period.
If during the hour Kelp wasn't producing at a consistent 32 megawatts, Northwestern would have to go and purchase more power to satisfy that gap, right?
Not necessarily capacity, but it would have to balance its energy requirements, yes.
Customers would have to pay more, right?
Not necessarily, no, because the Kelp energy would be priced at the LMP node, which is in Northwestern's avoided cost of energy.
But you told me Kelp would still receive its full capacity payment if it satisfied that 32 megawatt average.
I did. And if you don't have to buy replacement capacity, there's no additional cost there. And if the energy delivered is at the LMP price, then Northwest customers are not harmed and Northwestern is able to meet its obligations to its customers.
I disagree, but we'll move on. And that same averaging component applies to the non-summer periods, right? Where Kelp committed to 37 megawatts.
It's the same performance requirement on Kelp to deliver capacity during non-summer months, yes.
It still uses the same average, right?
It's based on an average hourly commitment during on-peak hours.
And for those periods, the highest fluctuation would be 32 and 42. Is that right?
37 and 42. Again, 37 in non-summer months is the capacity commitment.
Yeah, on average. So if you could produce up to 42, the average.
At 32, I apologize.
Yeah, that's okay. So
Yeah, 37 is the commitment in non-summer months, and setting aside the important issue of step-up voltage losses. 37 is measured at the metering point, which is in the balancing authority area. 42 is at the generator. There is a 5 megawatt swing in that. Yes.
So, but what I'm just saying, the 32 to 42 is the highest fluctuation to provide the average in the non-summer months, right?
Under your hypothetical, that's right.
Okay. So Kelp would only be guaranteeing 32 megawatts during those hours, right?
If we're talking about the non-summer period, the capacity commitment's 37 megawatts.
But only under that hypothetical, that would only apply in half the hours. Or it could produce 32 megawatts in half of those hours and 42 in the other half and still get its full capacity
I
payment.
want to be clear because you keep saying 32 megawatts and we're talking about non-summer period. Or are we talking about the summer period?
We're talking about the non-summer period. The average commitment is 37. So half the hours they could provide 32 and the other half they could provide 42 and still get a full payment, right?
Well, with the loss adjustment, there is a swing in the capacity component that still meets the average, yes.
Okay. And again, Northwestern wouldn't know in advance which half Kelp would provide under that scenario, right?
They will know Kelp's behavior under the contract. But in advance, they will know on a real-time basis.
On a real-time basis.
Yes.
Okay. And during off-peak periods under your proposed PPA, Kelp asserts that Northwestern may request it to provide additional capacity. Is that right?
With the limitation that Kelp cannot operate below 20 megawatts during the off-peak period. Otherwise, it would have to restart operations.
If Northwestern made the request, even under those limitations, Kelp could decline it, right?
In the off-peak period, yes.
In response to PSC 002 that the Public Service Commission issued in Discovery, you told the commission Kelp would have to comply with the request, didn't you?
Or, excuse me, Mr. Chairman, could could I please ask that the witness be provided a copy with the document that council is referring to?
Well, it's in the record.
And I appreciate that, but I don't think the witness has it.
So that's fine. I'll just ask it another way. If you told the commission in response to PSC 002 that kelp would have to comply, that would be incorrect then, right?
Again, I renew my request that the witness be allowed to see a copy of the document that council is referring to.
Yes, I think we're relying upon his memory of precise words, so I think that's appropriate.
Chairman O'Donnell, may Bobby approach the witness?
Yes.
Thank
you. Will you please review your response to PSC 002?
Well, this answer doesn't support your characterization, but it specifically, it says when Northwestern requests that the facility increases its capacity, is kelp required to comply or may kelp deny Northwestern's request? That's PSC 002B, and in response, it says yes, subject to the limitations in the agreement and other considerations in the agreement, such as forced outages.
So you responded, yes, it would have to comply, right?
But before we were talking about a 20 megawatt minimum commitment to run in the off-peak period. What this request is whether or not Northwestern asks kelp to increase capacity. There are limitations, and based on the contractual commitment, I guess they're not obligated to comply, but they have an economic incentive to comply. And that's largely tied to whether or not the energy rate supports their ability to deliver power in excess of the capacity level.
So they're not contractually obligated to comply.
Objection to the extent it asks for a legal conclusion.
I believe you just testified to that. Is there a provision in the contract that would say kelp had to comply with the request from Northwestern?
It's my understanding that kelp does have some discretion in ramping up production based on the LMP prices, expected LMP prices, but they do have an obligation to deliver the minimum capacity obligations during on-peak periods.
We're talking about off-peak periods.
Off-peak periods, there is a no capacity commitment for the off-peak period.
So if Northwestern requested additional capacity under your contract, kelp wouldn't have to comply.
They would have the ability to economically protect themselves during the off-peak period, which is true, but there are limitations for kelp. They have to operate at 20 megawatts, so they'll be available to operate during the on-peak period.
During an off-peak period, if Northwestern asked kelp to produce additional capacity, kelp could say no, right?
They could, but it's not as simple on kelp as you're characterizing.
But Northwestern would have no say over that matter, right?
But they have the contractual commitments for kelp during the on-peak period.
We're talking about off-peak.
Well, again, kelp's decisions for the off-peak is limited based on their obligations to meet their on-peak deliveries.
Yeah, so kelp, Northwestern's ability to request kelp for additional capacity in the off-peak periods is also dependent on kelp operating at its minimum levels, right?
Yes.
Okay. Northwestern won't know in advance whether kelp will be operating at its minimal levels until about a day before, right?
I would have to run that down with kelp, but they would have to know fairly shortly upon the day they're requesting some output during the off-peak period.
So Northwestern couldn't plan in advance for any of that additional capacity except for within 1 day or so, right?
Well, it's just not that cut and dry. Kelp has an on-peak obligation. They can't shut down during the off-peak period and meet their on-peak obligation. So Kelp does have to operate during the off-peak period. Whether or not they would increase capacity above their minimum during the off-peak period is not an obligation for Kelp, but they do need to meet their on-peak capacity commitments.
But Northwestern won't know during an off-peak period whether Kelp will be operating at minimum levels or not, right? That's up to Kelp. Right?
Under the performance-based structure of the contract, Kelp has some discretion in that, yes.
Okay. So again, if Northwestern doesn't know whether Kelp will be operating at its minimum levels and wouldn't know that until about a day or so in advance, Northwestern couldn't plan for additional capacity any further than that, right?
You're posing a scenario that I haven't investigated, so I can't give you a clear answer on that. That was a concern, but we could have looked at that prior to the hearing today. It's a very explicit scenario which has limitations based on, a coal-fired unit that simply doesn't have a throttle where you turn it off and on and run it. There are limitations on how a coal-fired unit can be operated.
I'm talking about your proposed contract. I get that there's operational limits, but I'm saying Northwestern has no control over whether Kelp will be operating at its minimal levels during an off-peak period.
Northwestern would not have control, but whether or not Northwestern would know what Kelp will have to do physically to keep its plant available to operate during off-peak periods. I suspect Northwestern would understand.
And you do agree that Northwestern has to plan for capacity in advance, right?
I do.
Okay. I want to run back to that 2.8%. I think I may have heard you incorrectly when you were talking about transmission losses. I think you represented that 2.8% was based on a study that studied from generators all the way to Northwestern's load. Is that right?
Yeah, that's based on the company's testimony from Mr. McGowan in the current rate case. Describes how they changed the transmission loss factor from 2.8% to 3.41%, I believe. And it describes the process in measuring transmission losses starting at the generator up to the balancing authority area.
If that study applied from the point of interconnection to Northwestern's load, then your argument in that regard would be incorrect, right?
Well, it's described in his testimony as starting at the generator up to the balancing authority area. So at some point, there are costs associated with transformational changes in the amount of voltage level generated in a unit and the cost associated with stepping that voltage up to a transmission level voltage. That is included in Northwestern's cost of service. It's a cost to provide generation service through a transmission system and ultimately through a distribution system, and then into retail customers' meters.
Did you conduct that study that determined a 2.8% loss?
I did not. I relied on Northwestern's loss study and I reviewed Mr. McGowan's testimony in the current rate case. And how that study was performed
And
at Northwestern.
And we don't have that testimony ahead of us right now. But what I'm asking you is if you misread it and that study actually only applied from the point of interconnection to load, that wouldn't cover any of those losses you're referring to between Kelp's generator and the interconnection point, right?
Well, then a detailed investigation would be necessary to see whether or not your characterization is correct. But I did not explore with Mr. McGowan the exact metering points of his study.
Okay, so if that 2.8% in that study was actually from the point of interconnection to the load, you agree that would be inappropriate to use for Kelp between its generator and the point of interconnection, right?
The interconnection, if it's on the low voltage side of the step-up transformer at the generating site, then yes, that would be at the generation voltage.
I'm talking about the point of interconnection with Northwestern's transmission system.
Well, for generators that are owned by Northwestern, that is, I have to step that back. I'll go by Mr. McGowan's description of the loss factor, which says it starts at the generator and goes up into the balancing authority area, which would be generally characterized as Northwestern's bulk transmission system.
And again, if his testimony actually said that was from point of interconnection on the transmission system to Northwestern's load, that wouldn't be appropriate.
Objection
Kelps.
asked and answered.
He didn't answer. He went off on a tangent, talking about other things.
I sustain the objection.
Okay, so again, we're talking about you want to increase losses from the point of Kelp's interconnection to the load, or to the Kelp's generator to the point of connection on Northwestern's transmission system. So that's capacity that will never actually reach Northwestern's transmission system, right?
Yeah, that's right. It would be capacity delivered into the balancing authority area for Northwestern.
So customers would have to pay Kelp for capacity that never even gets on Northwestern system.
Like they do Northwestern,
I-
they would pay for the cost of generation to deliver power into the transmission system or the balancing authority area.
I'm asking you about Kelp itself, not any other generators. You're asking the commission to approve a 2.8% increase that would reflect losses that Kelp never provides onto Northwestern system.
I am, because it's a fair treatment for that cost.
Okay, so let's go to energy payments. In your direct testimony, you also increased Kelp rates by 2.8% as well, right?
By direct testimony, I did, yes.
Okay, and you based that on that same 2.8% we just talked about?
Based on a review of integrated resource plan documents for Northwestern, where they made similar adjustments for power delivered to their system.
And on page 16 of your testimony, you requested that Kelp receive energy payments based on a LMP day ahead price, right?
Yes.
Northwestern doesn't even have access to a day ahead market, right?
Well, they do. That's, the energy imbalance market doesn't yet have a day ahead market, but bilateral contracts can have day ahead market pricing. The CAISO tracks day ahead marking prices for the LMP HUD serving Northwestern.
So again, does Northwestern, outside of bilateral contracts, is there a current market in the EIM for day ahead rates?
Currently in the EIM, no, but outside of the EIM, there is.
Are you aware that Northwestern is a participant in the EIM?
I'm relying on Northwestern's testimony when they first sought to include a pre-approval for the Laurel Generating Station, which is now the Yellowstone Generating Station. I believe it was Mr. Roy indicated that the benefit of that facility will allow it to reduce its participation in day ahead in real-time energy markets. That in combination with the RAP program, which is designed largely on capacity planning for a day. And I have reviewed some PPA agreements that it's confidential. I can't say what I reviewed in those. I think it is consistent with Northwestern's current practices.
Northwestern is a participant in the EIM. This is real yes or no question.
Well, that's a new question, and yes, they are.
Okay. And you don't operate Northwestern system. You don't sell energy or power for Northwestern, right?
I don't, but I do observe Northwestern's discussions of generating plant justifications.
You also requested that Kelp's energy prices be based on Colstrip Unit 4's node, not the Rosebud node, right?
I do, because I don't think the Kelp node accurately reflects the avoided cost at Northwestern if the Kelp contract is not extended.
The LNP prices at the CO4 node are generally higher than the Rosebud node, right?
Based on my examination of the two nodes right now, there's not a lot of difference, but there might be a little higher price at that, largely because that's, as I understand it from Mr. Cash's testimony, the primary corridor which Northwestern conducts energy transactions.
Where will Northwestern receive power from Kelp?
Rosebud.
So the Rosebud node is the receipt point on Northwestern system where it will receive power from Kelp, right?
Yes.
To be clear, the CU4 node is not the receipt point on Northwestern system. Will it receive power from Kelp, right?
Not if Kelp's delivering, but if Kelp's not delivering, then there will be no deliveries to the Rosebud node.
Yeah.
So they would have to make it up through some other node,
Kelp's not providing power to Northwestern through the CU4 node.
through the Rosebud node or the C4. Well, if Kelp's contract is not extended, they won't deliver to the Rosebud node. They're currently not delivering to the C4.
Yeah, Kelp does not deliver to Northwestern through the CU4 node, right?
Just said that.
I got lost in everything else you said. And the mid-C price hub is not a receipt point on Northwestern system where it will receive power from Kelp, right?
Now I'm getting lost. Can you repeat that, please?
The mid-C price hub is also not a receipt point on Northwestern system where it will receive power from Kelp, right?
That's right.
Okay. I'm done with my direct testimony. If we want to move on to rebuttal at this time, I think that'd probably be most efficient, but I'll leave it up to you guys.
You may proceed.
Thank you. In rebuttal, you conceded that 2.8% transmission loss adjustment is not appropriate for energy rates, right?
I conceded it because, as Mr. McCarthy pointed out, the loss factor adjustment is already included in the LMP price.
Just answered my next question. So you didn't know how the LMPs worked when you filed your direct testimony?
I missed the fact that the marginal losses were included in the LMP prices. It was an oversight on my part.
And Mr. Quinn McCarthy had to point out that transmission losses are already considered in the LMP prices, right?
As I just said, that's correct.
So you were originally including increased rate adjustments that would have been detrimental to customers, right?
Not if the LMP had not included marginal prices, but inclusion for the energy price is inappropriate if the losses are already reflected in the price.
Right, but we just established LMP prices do include those. And when you filed your direct testimony, you also included a 2.8% increase, right?
And over that, that's right.
And that would have been detrimental to customers then if we would have accepted your proposal, right?
Would have, but as soon as Northwestern communicated that the losses are in the price, we withdrew the request.
Right, but we had to point that out to you first, right?
In negotiation, talking to the counterparty helps to resolve issues. That's correct.
And again, that's because you didn't know how the LMP worked.
There was a loss adjustment that I was not aware of, and once you made me aware of it, I modified my testimony.
So do you agree that Mr. McCarthy helped save customers from increased rates from your original proposal?
Mr. McCarthy communicated with Kelp, and we modified our proposed pricing in accordance with that constructive communication. Yes.
And that reduced costs for customers?
Resulted in a lower energy price by removing the emission loss adjustment.
Okay. And your proposal for the day ahead prices and using the CU4 node was the same on rebuttal that we just talked about on direct, right?
Yes.
We're good there. And for capacity rates, you maintained that 2.8% adjustment for transmission losses, right?
Yeah, because the adjustments in the capacity price need to be reflected. Otherwise, the capacity price will understate what it costs.
And in your rebuttal testimony, that's the first time you ever said anything about generation voltage step up, right?
Well, there was a discussion, the testimony, which required clarification of the issue. At that point, that is when I clarified my position.
Right. So that was the first time you used the words voltage step up, right?
I believe I used that in direct testimony, so I believe.
Okay. Okay, let's talk about proxies. You claim that a 50 megawatt aeroderivative at DG Jets is not an appropriate proxy because it does not have a firm fuel supply, right?
One of the reasons, yes.
Okay, does Kelp have a firm fuel supply for its operations after June 30th, 2024?
It is it's contacted its fuel supplier, which has expressed interest in extending the fuel supply contract. So once it has a capacity agreement in place, it will make arrangements for contractual counterparties to allow it to operate through the term of the contract extension.
Kelp doesn't even have a firm fuel supply agreement for waste coal after June 30th, 2024, right?
It is putting together the purchase power agreement first. It is in contract with the fuel supplier to get indications of interest of extending the fuel supply, which was met by a positive response. So it is in the process of putting together the contractual arrangements to allow it to continue to operate its facility going forward the same way it has in the past.
Okay, right now, as it exists today, after June 30th, 2024, does Kelp have a fuel supply agreement?
Not have a contract yet. It is waiting to first establish the purchase power agreement, contract extension period, which point its talks with its other suppliers will be pursued for contractual extension.
And those contractual extensions would be subject to negotiation between the supplier and Kelp, right?
Confirm that, but I presume that's true.
So there's no guarantee that the supplier could provide a firm delivery after June 30th, 2024, right?
I think that is part of the discussion between Kelp and the coal mine. And it's my understanding that the coal mine is able to delivery obligations, contract extension period.
But there's no firm agreement right now that would give a firm fuel supply after June 30th, 2024.
There's no contract yet because there's no purchase power agreement that gives Kelp the financial viability to execute such a contract.
Right. So there's no guaranteed terms of firm commitment, right?
Excuse me, I believe the witness has answered the question very definitively.
You sponsored data requests Northwestern Energy 10, right?
Have that list, but probably.
It's the one where Northwestern requested Kelp's existing fuel supply agreement, right?
Yes.
And Kelp tried to keep that from the commission's purview, right?
Objection, argumentative.
Did Kelp, it's okay, I'll waive that. Did Kelp object to providing this document discovery?
I think it was competitively sensitive information and they wanted to keep it confidential.
But they objected altogether on providing it even prior to moving for a protective order, right?
I don't know all the details of the back and forth between Northwestern and Kelp on that fuel supply, but I do know it was competitively sensitive information.
Mr. Hamilton, I may need to present some confidential information at this point. I'm going to confer with Kelp's counsel first. I'm going to present confidential information. Lucas, if you want to switch the Zoom over, please.
Yes, Mr. Chairman, if it's all right with you, I'd recommend that we take a brief 5-minute recess to switch over, test the confidential version, escort any individuals in the room who cannot be present for the discussion of the confidential information out of the room, and then proceed with the hearing.
So ordered. 5-minute break. It is now 10:54.